I'm Claudine Ewing in Buffalo. I had a chance to speak with several New York State lawmakers about bail reform and orders of protection. This conversation is a result of the recent death of Amanda Thompson, but she was not the only one. There was Kiara Hudson. There was Tania Wilson out of Niagara Falls. When you heard about this case, and you once sat on the parole board, you once were the sheriff, now you are a state lawmaker, who bailed this woman?
Well, clearly the defendant did. And first and foremost, we have to put this on the defendant, the bad actor, the person who injured another, or who killed another person, who's proven that he's done it in the past, who fled from the police, who clearly was a risk and clearly a danger to the community. When we look at this individual and how it ultimately happens, and I shouldn't say it's allowed to happen, but that it can happen, it's natural that we look back at our system and question whether the system has faults. I think there's problems all along the way. So I served on the parole board. That's the first time I became aware of discharges from parole. So that somebody who is serving a sentence on parole, if they follow the terms of their parole, if the parole board feels that they have potential to live a law-abiding life, there's a mechanism that allows the parole board to discharge an individual from parole. That's something I was never comfortable with, because if we take a step back and look at an individual who's convicted of a murder, for instance, like Ricky Crouch was, and he's got a sentence of, I think it was a 15 to 25 year to life sentence, released on parole, the community and the victims have this expectation that he's going to be on parole for the rest of his life. And lo and behold, there's a mechanism to release somebody from parole after 3 years. And I think that happens too many times. And I think when we look at what I call more permissiveness and we look at the laws that have been established over the last 7-8 years that in my view favor offenders over law-abiding citizens and are not balanced to help protect public safety, we see more and more releases from parole. But that's just, he was discharged, and if he was still under parole supervision, would this have happened? Maybe, maybe not. We have the bail reform. And I agree with the district attorney in the sense that this is not a true failure of bail reform case, because inherent in this, a judge had the opportunity to remand this individual without bail, to hold this individual in custody and exercise discretion so that the individual was back out on the streets and ultimately committed this crime. But if we go back to the law itself, New York State is the only state in the country where a judge cannot consider public safety or the dangerousness of an individual in making a bail decision. And that's a problem with our law. That had nothing to do with the changes to bail and the so-called bail reform, but the law is still problematic. And I think those are just a couple of things that are in the law that contribute to more victimization.
Is that something, because you see the ins and outs of it, and this is a perfect example of not considering those previous crimes, is that something that can be tweaked?
Well, clearly it can be tweaked, but we have to have enough lawmakers who have the will to do this. Political will, if you must, but it's just beyond me that we have people that represent communities where individuals are victimized time and time again. We see repeat offenders like this that ultimately lead to, didn't just kill one person, killed the second person as a result of all of this. And for some reason, we've got many lawmakers that are considered about the rights of a perpetrator as opposed to the rights of a community. Why do we have drug-infested streets in certain areas? Certainly there's some sociological reasons, but as lawmakers, we can do something about this. We can tighten the laws as opposed to loosen the laws. And that hasn't happened over the last 7 or 8 years, and that's really unfortunate. And what we see as a result of this permissiveness, what we see as a result of laws that are not balanced to help protect public safety, when we see laws that our lawmakers, the majority of them, have refused to permit judges to consider dangerousness or public safety in bail determinations, it leads to things like this, unfortunately.
When you look at Ricky Crouch's background, 1996 murder, paroled early, got an order of protection, Amanda did, because of a burglary and an arrest. He was sentenced before at 23 to life, and as you mentioned, after 23 years, he served his time and then he was released from parole. I don't think many people paid too much attention to that fact. Most people would think, oh, okay, well, he served his time, he did parole, they dismissed him, so, he's okay, he's right. It's not always that way.
Well, in the eyes of the law, when somebody has committed a crime, served their time, released from parole, that individual, under the eyes of the law, is like every other law-abiding citizen. And they don't necessarily carry that baggage with them, presumably in their day-to-day life. If they're charged with a new crime, that look backward doesn't necessarily count.
But it should.
Well, I understand why it doesn't count with the new crime itself as far as the charges, but it certainly should carry weight in a bail determination.
Yeah.
And a judge certainly should be able to consider the dangerousness to the community.
Is that the part that outrages you most about this case?
Yes, it's well, not just this case, but many cases. It just baffles me when we say, gosh, this person did it again. It happens time and time again. We see instances of repeat offender after repeat offender after repeat offender victimizing additional individuals, whether it's a larceny, whether it's a sex crime, whether it's a violent crime, whether it's a murder. And that clearly is the result of bail reform writ large, not necessarily in this case. But the real problem, in my view, with bail reform, well, two things. The one, where the reform did not touch the dangerousness part of it. That's just something that should be introduced. Mm-hmm. But bail reform has really, now that we have a number of years of it under our belt, a few modifications, we can see where the problem is. And the problem is with repeat offenders. The laws are not strict enough. The police, the judges do not have enough tools to be able to do something about it solely because of the bail reform laws, even though that does not have a direct application in this case.
Orders of protection. Amanda Thompson had an order of protection. I'm thinking of other cases. Kiera, the woman who was shot in her car, yeah, had an order of protection. Up in Niagara Falls, the woman had an order of protection. It did nothing. It did nothing. What can be done to strengthen laws when it comes to orders of protection so that people don't feel like you can just go violate it? Because often when it is violated, it's the worst.
I think several things. We can make the penalties more severe. We could also, if somebody is charged and ultimately convicted of violating an order of protection, we can put laws forward that do not allow those cases to be plea bargained away. Meaning, if you're convicted of that or you're charged with that, you go all the way. Mm-hmm. I mean, meaning you go all the way through conviction and the imposition of severe penalties. It can be done. But I think this goes back to our bail laws. Because if we had a bail law that the judges were allowed to consider dangerousness, then I think the use of that tool could give more teeth to the order of protections that are out there. They still can carry severe penalties, and they are still felonies, and depending on the circumstance, they can be punishable by up to 7 years in prison for violating the court order. But you just don't see people punished for it at all. Generally, you might see them punished for the burglary, you might see them punished for the murder, you might see them punished for other things, but usually the violation of the order of protection, which is really a criminal contempt of court, typically goes away, and I don't think that it should. But I do think the answer goes back to our bail laws. 49 other states are on to something when they consider public safety in the remanding of an individual or making bail determinations. And clearly, if somebody has an order of protection against them and has violated that order of protection, they've demonstrated that they're a danger to somebody.
Yeah.
And
sure.
I don't think that that individual should be allowed to go free like the rest of us law-abiding citizens.
When you look at his criminal background just with Amanda Thompson, so it was on May 20th where he had his first appearance in court. He was arraigned before Judge Farrelletto, but everything after that, when he went to before Judge Carrie Ann Phillips, it was transferred to another court, adjourned. But this is the part that angers people. He was referred to problem solving, alternative court program, temporary order of protection given, that's adjourned. Arraigned, pled not guilty, bail set at $50,000, partially secured or bond. He was able to meet one of those conditions, so that's how he was able to get out. Why is this bail $50,000 and so many conditions so that it's so easy to just get right out, knowing that he went to prison for murder before?
Well, I don't know all the facts of the case. I certainly know what has been publicized and what's been in the news time and time again over the past several weeks. We should allow judges to do their job and exercise their discretion, and then there's an appropriate time. Judges are elected also, an appropriate time for the public essentially to pass a review on the judges, whether they're doing their job properly or not.
Do you think some judges are just fearful of the backlash if they aren't a little lenient?
Well, I think it's possible, and I think there might be some political pressures on the judges. I can't say that that's the case here. We don't know that. But a judge did set bail in this particular case. I'd suggest that the judge did have opportunity to remand the individual because of the nature of the charges.
But she couldn't look at the past crimes, right?
No, but I would suggest that this individual had a history of running, and in his first arrest, he dumps a car, he runs from the police until the police ultimately have to catch him. And he's done that time and time again. Can you make that connection that that he might not return to court? That he might flee and not come back to court? I don't know. I mean, I would suggest that it's there, but I think it becomes very difficult to sit here today, Monday morning, quarterback a judge's decision without knowing all the facts that the judge had at their disposal. When we look at it now, it certainly looks problematic. I think the problem is in the law, and I would like to see judges in general err on the side of caution as opposed to erring on the side of whatever political pressures there might be, again, without knowing that that's what applied in this particular case. $50,000 is a lot of money for somebody to make bail. He made bail.
But it's, if you have the cash, but there's so many conditions with that. Like,
but given his history, it's problematic. And he immediately, that day, he's released on bail and immediately violates the judge's orders.
The same day.
And for the life of me, after that happens and you're brought before a judge again, I don't know how that person is out on the streets after that.
Yeah. My final question has to do with if judges are going to err on the side of caution, as a lawmaker, what would you suggest? Erring on the side of caution, considering the community, the public safety, or is this erring on the side of discretion for the defendant? Because there seems to be a disconnect. The
bail laws, though, no, it's interesting. While I say that it might not be appropriate to have said judges making a decision to err on the side of caution or not. What's inherent and what's written right into the bail laws is the judges do have to look at, and this is a flawed law in my opinion, what's the minimum that they can do that can reasonably assure that that individual will come back at court. So the judges have to weight their decision on those words that are in the law. And I think that's a problem in the law because that then, in my view, tips the scale, even though you're not allowed to consider it, tips the scale away from public safety and focus solely on an individual who has already demonstrated, at the very least, that there's reasonable cause to believe that this individual did something the rest of us don't do, mainly committed a crime and victimized somebody, the community, or an individual.
Do you think?
And this person clearly had a history of that everybody was aware of, and that's something that should be in the law to allow judges to make determinations as it relates to public safety.
Do you think we'll see change?
I think it's very difficult. With my time in the legislature, particularly over the past 7 years, I see a tremendous reluctance in the majority of legislators who right now, essentially through their collective vote, control policy in enhancing penalties or further restricting somebody's liberties, even though they might be merited. Right? We always have to balance the individual liberty and public safety. But when we've got somebody that's crossing the line and victimizing others, that's not fair to the rest of us. It's not fair to law-abiding communities and law-abiding people across the state. I would hope that a case like this opens enough lawmakers' eyes to do something about it. I don't know that I'm that optimistic about it, though.
I'm a co-sponsor on a bill that's Senator Pam Helming is a prime sponsor on. It's S3453 that would do that. It would require something that currently my Democrat colleagues don't want, and that's that the judges be able to allowed to consider the dangerousness and their past history when issuing these orders of protection. And really the violation of the order of protection is the issue, right? In this tragic case, you have a career criminal who committed murder, who violated the order of protection more than once and still couldn't be returned to prison. In the old days when, before the so-called Democrat criminal justice reforms went into place, that would have been a parole violation and he would have been sent back to prison. But that doesn't happen anymore because we have less is more. Less is more considers something that's a technical violation. So choking out a woman is not enough to send you back to prison for violation of your parole. Then I don't know what is. First and foremost, you can strengthen the laws, but they need to be enforced. And also, we need to actually show that there are consequences for violating things like that. And right now, my Democrat colleagues and their rhetoric that emboldens criminals, that says to them that they're victims of circumstance and political prisoners and not criminals that have committed heinous acts of violence against other New Yorkers. That rhetoric is what has emboldened scumbags like this to commit atrocities like this.
And now we get to the whole issue of, some would say it wasn't bail reform, others say it was bail reform that led to this. Somewhere the system went wrong in this case. When he broke into her home, bail was set, he made it, he wasn't remanded. This is somebody who did serve time, over 20 years in prison. So he served his time. He was on parole. He finished parole. So he did his time. But how do you not take into consideration that type of background when you can kind of see a repeat offense about to happen? He broke into a home of a woman he had a relationship with.
Well, again, this is because Democrats and their twisted social justice war and creating new victims is just a acceptable casualty for them. And this is a perfect example of that. They will not allow judges to consider a dangerousness and a past criminal history. They are required to set bail at levels low enough that that particular criminal can actually post bail. But it's a combination of things. It's bail reform. It's less is more. It's the rhetoric of my Democrat colleagues, as I mentioned before, that paints these criminals as the victims. It's the fact that judges' hands are tied with the fact that we are the only state out of the 50, the only state that does not have a dangerousness standard, that judges are not allowed to consider someone's past violent history as a reason to remand someone without bail. So we've continued to tie the hands of our criminal justice system, our police, our judges, our parole officers, in order to meet this twisted social justice agenda of Kathy Hochul and her fellow Democrats in Albany. And that's what led to this tragedy, period.
I mean, you're very straightforward. You're to the point, and I think for most people watching this and listening to this, they don't even care about the politics of it. Something has to be done. Um, what do you tell viewers across all lines? Is there something that George Borrello can do? Because this just can't keep happening. And you know, like I know, it will happen again unless something changes.
It is happening again. New York State has seen a spike in crime in almost every category, and it is all directly related to the changes to criminal justice laws that date back to 2019, and we continue to see more and more things like this pass in Albany. There is no remorse on the part of the Democrats, and so what can George Borrello do about it as your state senator? I can bring it to your attention. I can bring it to the attention of the people in Western New York who have to hold accountable their members of the Senate and the Assembly who vote for these things. That is the only solution here. The system in New York State, unfortunately, is rigged. It's rigged to give the majority almost complete power over what happens here, and it's also rigged in the sense that people aren't necessarily able to relate the things that pass in the middle of night in Albany and how they impact their everyday lives. So you may say, well, we don't want to talk about the politics, but it's all about the politics. It's about the politics of this social justice agenda that Democrats have inflicted on the people of New York State. And like I said, creating new victims isn't a problem for them. Because their job is to put criminals over victims. The whole point of all of these criminal justice reforms is to give preference to criminals over public safety, and that's the problem. Kathy Hochul has been all in. She's rattled her saber once in a while in Albany, saying we have to change this, and then she gives in, she folds. So what I want to do, and I'll continue to do, is to call out this dangerous hypocrisy, to call out the injustice that we see in things like this. You can look at statistics on a page, but when you see this victim, Amanda Thompson, who died directly because of the criminal justice reforms that were made under Kathy Hochul's watch and the Democrats in charge, that makes this real. And I hope the people of Western New York in particular understand that these are the consequences of politicizing public safety.
Yeah, I think you're spot on with what you're saying. And though there will be people who say don't take the politics out, you have every right to say it is about politics because that's where it started, right? It
That's right.
started in the New York State. It started in New York State government. This is why we have this right now. Is there anything else you want to say or anything that people can look forward to seeing, or is there anything that the people can do?
I think people have to understand that right now, giving judges something in New York State that literally every other judge in every other state has is absolutely a necessity, and that is to give them the ability to evaluate someone's on the basis of their dangerousness. This is critical. A judge needs to be able to look at a guy like that and say, we need to hold him without bail. It's not about money. It's not about rich versus poor. It's about someone who is a danger to other folks and should not be on the street. And people need to understand that. If we can give judges discretion, which is what this is all about, it's giving judges discretion to hold someone based on their past history, on the level of dangerousness they are, the dangerousness level to them and others, that is the key to at least starting to address this. And I've debated this in Albany. I've had debates with my colleagues on the side of the aisle where they say, how do you define what dangerousness is? That's the ridiculousness. Literally, they feel that it's not within a judge's ability to decide whether someone like this, with a long rap sheet of violent acts, including murder, is not a danger to society. That's what Democrats think that is the reason why we cannot give judges discretion to hold someone. It's outrageous, and it's counter to the basic job that we are supposed to do as elected officials. Our number one job is to keep our constituents safe. And Kathy Hochul and Democrats in Albany have failed miserably on this over and over again, and this is just one more example.
So, as a result of the Amanda Thompson case, we have to talk about bail reform. We have to talk about orders of protection. And then you think about Amanda, you think about that Kiera Hudson, another woman who had an order of protection, was killed in the car in front of her kids. Then you have up in Niagara Falls, a woman, Tania Wilson, also killed by her estranged boyfriend, possibly husband. A police officer who is now a Cheektowaga Town Council member, I asked him about orders of protection. Is it a piece of paper? And he said it is.
To me, the bigger issue is this, is that New York State, systemically, since 2018, 19, 20, we have passed legislation throughout the entire criminal justice system that has essentially defaulted and basically created deference and forgiveness to those who have been accused and convicted, and contempt for victims and law enforcement. And it's not just bail reform, but we'll start there because that's the topic. There have already been amendments made to bail reform since 2019. And I think the biggest one, but the intent behind it, and if you go on the governor's website, if you look at what the governor says about the changes, the intent and spirit of the bail reform remains. And what we essentially did was, and again, I wasn't a member of the legislature, so this is my interpretation of it, is that we, the legislature, instructed the courts on how to essentially view, and we gave them instructions for how to approach bail. And the term is least restrictive means. That was the term. Now, it was taken out in 23, but we made a distinction without really making a difference in terms of what that means and how a judge is supposed to apply that. So again, while the governor may say, and the majority may say that we have restored judicial discretion, we really haven't, because once you go into the actual text, the crimes that are eligible have reduced significantly. So a judge's discretion really isn't what they're saying it is. If you want to hold somebody, you still have to justify that in writing if you're a judge. So again, the default setting has ultimately become release.
But women are dying.
Oh,
Men are dying. People are dying.
I understand that, which is why I think we should repeal bail reform altogether.
What would you suggest be done immediately?
Repeal bail reform. Repeal bail reform to where it was, basically start over. Because the way that we're heading now is not really good for public safety. And again, I think that public safety ultimately goes into an economic issue. I don't think it's good for the economy either. And again, like I said, it's not just bail reform. Let's get into some other topics here. We've obviously seen the corrections officer strike earlier this year. Again, that what I was talking about before, where it is those who have been convicted or accused of a crime, we're showing deference and forgiveness for those. But then our law enforcement and our victims, we're essentially showing them contempt.
So basically you're saying the convict is getting the upper hand. You're getting the hug, and the person who's the victim is getting shoved aside.
That really is. And again, we look at it within the actual, like, look, we just closing two more prisons. We saw that in the budget this past year. When we made any type of prison reform or reform to our criminal justice system and our corrections facilities, the COs really were not a part of that discussion. So that's a problem. On the floor of the state assembly, we get admonished if we actually say the term convict or inmate. We have to use the term incarcerated individual. You would actually literally go on the assembly website and find this, and it's gotten that bad.
Right.
And again, it's not a malicious term, inmate. It's just common vernacular of
Well, that's what the everyday
individuals.
person is saying.
Exactly.
That's what the person who is incarcerated is calling themselves from time to time too. So there have been amendments to bail reform, and as you mentioned, it's not working.
No.
Why is Amanda Thompson dead when there was an order of protection? When it comes to orders of protection, they are there to protect someone. But what's the penalty for when people violate it? Has anybody thought about looking at that? Because in each of those three cases, there was an order of protection that was violated, but usually when it's violated, the person comes up dead.
Well, the worst part about it was, if I understand this correctly, Amanda Thompson's accused murderer was already convicted of murder.
Yes.
Served
his time, was on parole. parole also
Yeah,
ended.
I don't.
It did.
Yeah, what I'm saying is any situation where that individual then has an order of protection against them should not be out on bail. I just don't know how else to say it.
So was that a failure of the judge, or is that an
This
indictment
is-
on the system?
This is where there is a nuance, and this is where it's important to understand, because nothing happens in a vacuum. While the judge, I guess, technically has the ability, because I think he did it against the DA's recommendation, the legislature has inserted itself by making these adjustments to bail reform into the judicial system by essentially directing judges how to act and how to make determinations.
So who's to blame?
I would say the legislature. I would say the entirety of the New York State government. And again, one of the things I ran on, I talked about, was repealing bail reform in its entirety and starting over again. And again, look, are there obviously situations where accused individuals and their rights are violated? Of course, of course. There are ways to amend that, but as you said, orders of protection, people like Amanda Thompson should be with us right now, and they're not.
And I know, and I'm not going down this race road, and I know some people will say, well, the reason you have bail reform is because you have to look at race, you have to, who's being incarcerated, who's being locked up. But right now we're talking about 3 women, a white woman, a black woman, another woman who may have been Hispanic or whatever, but this is happening across the board. This is about life and death, and it's all coming back to laws.
Yeah.
Like, why isn't there something stiffer when you violate an order of protection? The first time he broke into the house, not locked up. Does that go back to?
I think it does. To me, when we talked about the system, I was watching the council. I was actually watching the Channel 2 news piece where the councilman was kind of talking about a systemic failure across New York State. We look at, again, all of these different types of laws that New York State has passed, from the bail reform, HALT Act, the closure of prisons. I don't like to use the term law and order because I think there's it's too ambiguous. But systemically, New York State has a real problem right now, and in terms of its criminal justice system. And like I said, I'm going to keep repeating it. Right now, we have reached, the pendulum has swung to deference to accused and convicted, and contempt for victims and law enforcement. And that pendulum needs to swing back the other way.
What else do you want to tell us about this? I know you brought some notes. Is there anything specific you want to bring out? Because I think what you've said so far has been spot on, addressing that there are problems, they need to be addressed. Is there one solution?
I think when we say New York, and I've learned this just from being in the state assembly just for 7 short months, a lot of times what will happen is that we'll pass a piece of legislation that has a nice ring to it. We'll make amendments that have a ring to it that sound great to the public, but we'll use this term, it's a distinction without an actual difference. While, again, in 2023 I was not there, but they passed legislation, an amendment to the bail reform that would remove the piece, specifically least restrictive condition.
Correct.
I'm just going to read it. But continues to limit judicial discretion by requiring judges to determine that the degree of control they impose necessary to assure court attendance with judges still required to justify those findings orally or written. So we're putting an onus on the courts to justify why they're holding somebody, not why they're releasing somebody. And I think that right therein lies the problem. We need to, if you're going to release somebody, you have to justify why you're releasing them, not why you're holding them. And if they're a danger to someone or a society, you shouldn't necessarily need to justify that. As a judge, you are there because we as a society are entrusting you to use your judgment and saying, yeah, we should be holding this person on bail because he is a danger to society.
Were you more alarmed with the fact, and this is my final question, were you more alarmed with the fact that this person burglarized the home, allegedly? There was an order of protection after that and wasn't locked up, knowing his past?
Yeah. I mean, yes. And again, we can see like recidivism rates in the criminal justice. I mean, there is data to back up the fact that this gentleman should have been held. You know, and something else that I've also this has been floating out there, and you know, has concerned me a little bit. There have been talk with some of my colleagues about removing police officers altogether from domestic violence situations and just having social workers. If that would have been the case in this particular situation, you may not just have Amanda Thompson that was murdered, you may have had a social worker as well. So again, it goes back to that contempt from law enforcement, that distrust in law enforcement. And again, I think it's important that we rebuild the trust with our law enforcement community. I think that's really important. But to not have them present in potentially dangerous and violent situations, you're going to end up with more people and more victims than less.
So I carry the Justice for Rachel bill, which was named after Rachel Weirs-Bickey, who was killed in a domestic incident, and her alleged shooter, who was later found not guilty in a court, was released on bail. This was pre-bail reform, and it was rather shocking at the time. The person had admitted shooting Rachel on the phone to paramedics, and through some machinations of, you know, some mistakes made, I think, in that court process, he was found not guilty. Put that aside, the point being is that domestic violence is a serious problem in our community. The Justice for Rachel bill creates judicial discretion in dangerousness hearings for these types of situations, that it can go to a second decision-making process to see if someone should be released on their own accord or not. Now, the problem that we're seeing with the cases that you're mentioning is that they were bail eligible offenses, and the judges decided to release them. The problem when we keep demanding more judicial discretion is that when it's granted and we're seeing judges make these decisions and we don't like the decisions, what do? So we can't keep blaming bail reform or even saying, you know, it's part of this when it explicitly wasn't. If judges had the power to hold someone and chose not to, how do you say it's bail reform? It isn't. It's decision making that led to tragic consequences.
Yep, and I hear exactly what you're saying, and obviously, you know, those on the other side would disagree with you because they're looking at.
Well, Claudia, let me, and I don't mean to cut you off. Just because someone disagrees with me doesn't mean that they have the facts on their side. It isn't an opinion that these judges had judicial discretion and chose to release them. It's a fact. So just because the other side, and then you have to look at what the other side, what is their incentive to reflexively blame everything on bail reform? It seems quite actively political to do that, but it doesn't make anyone safer. We've done multiple changes, and I've led on multiple changes to bail reform. I heard a political candidate just recently, blaming all of these things on bail reform and saying, well, it's the least restrictive component of bail reform. The judges may have more types of crimes that they can assign bail to, but they're required to have this least restrictive component. The fact is, that's not true, because we changed that in 2022. The least restrictive clause isn't even there. Some of the more further left-leaning colleagues in Albany went on a hunger strike because they were so mad about it. So I just don't want us to get to a situation where we just both sides it rather than focus on what the truth is.
I hear you loud and clear. And I did speak with another lawmaker, and I said, put the politics aside. And he was very clear, no, you can't put the politics aside of it. But in the end, it's about life, right? And I think both sides should be about, how are we going to save lives and protect people?
Well, and I don't, and I'm sorry, I want to just push back a little bit because we need to save as many lives as possible, but we all pledge allegiance, and the end of that is liberty and justice for all. Liberty and justice for all has to mean something. It means we have liberty and we have justice, true justice for everyone. And we can't do that if we just lock people away before they've been convicted of crimes without evidence. You can't just say, well, it's exclusively about this. Like, we have to keep people safe. You can't have a society that functions without keeping people safe. But we have laws and we have standards and we have a constitution for a reason. We have to abide by it. If one political side goes out of their way to make everyone feel afraid, in spite of the fact that crime is at some of its lowest levels, and then they blame everything on bail reform, is it about the law? Is it about keeping people safe? Or is it about making people feel afraid and feel scared because they politically benefit from that, from people being afraid and scared? We are at, aside from just this law, we are at a very dangerous point in our society. And when you have people actively fomenting fear and anger and hatred, it creates a situation where we're all less safe. And we know that, and we've seen that, and it's been abundantly clear over these last few weeks.
You're right about that. Let's talk about orders of protection.
Sure.
What can be done to make sure that they truly work? I asked a former member of law enforcement who is now a lawmaker in a local town, and I said, it's, most people would say it's just a piece of paper. What can be done to strengthen it so that it is not just a piece of paper, that it does mean something?
Yeah, I don't honestly, I don't have all the answers. I think having a more, active and aggressive response specifically to domestic violence. There's all these little things that we can be doing. Having more police presence around, individuals who are under, threat from a domestic partner. And I actually do think we can still make more changes to state law to specifically to domestic violence. Even minor domestic violence incidents can often be a signal that there's greater things to happen. But again, we do have to be careful with how we restrict people's freedom. But I think there are some changes to the law that can be made.
I really appreciate your time, and I appreciate your candor as well. And hopefully we can talk more on this later on. Is there anything else you want to add?
Yeah, I would re-emphasize that we do have regular trainings for judges, and I think this the discussion of like, oh, there's nothing I can do because of bail reform really indicates that they aren't updated on the law. There are courses to take it. I personally think they should be mandatory. I also think there's an important component to talk about that, lower court judges, town judges don't even have to be attorneys. And often in cases they aren't. So they're not really experts in the law, which creates, I think, real questions of safety. And I think I think in several instances we've seen where people who aren't attorneys, who don't have a background in the law, are making decisions on other people's safety, and it leads to some tragic consequences.
Thanks for watching WGRZ Plus. We'll see you next time.